T-1s and EB-1A visas for athletes, entertainers, and professionals from all around the world. Today, I'm doing a late night video in my UFC London t-shirt. This particular one was the Aspinall fight where he didn't win a championship yet, but he was well on his way. Kicked a lot of tail that night. But let's get into it. As student athletes in the United States are able to take advantage of name, image, and likeness opportunities, there is a great need for a lot of students that are currently still in school to switch over to P-1 or O-1 visas so that they can have the work authorization required to receive payment for their NIL activities in the United States. Now, this creates a couple of issues, especially if you're a current student and need to make sure that you have status. So in this particular circumstance, we have an inquiry from a golfer who is a highly ranked amateur golfer around the world and has a great background and accomplishments in golfing through their NCAA career. And prior to that, they were a national team member at the youth level. They are looking to switch to a P-1 visa so they can take advantage of some NIL opportunities they have coming in the pipeline. The issue is they need to travel back to their home country for a couple of weeks and come back. And the question is, when should they file for their P-1 visa? The answer is file for your P-1 visa right away. And the reason that is because while it's pending, anything could happen, but you always want the opportunity for something to happen, whether it's approved or a request for evidence comes in, especially if you're going to file under regular processing, because it's just going to take time. The thing is, once the visa is filed, we can always change it from expecting to be consular process to be approved while the person's in the United States. So what we would do is file the application and let the person travel and go ahead and extend their F-1 visa status. So that way they have the option of either going to the interview for the P-1 visa or to extend to F-1, but they have a bona fide way to get back to the United States. If it's the case that the P-1 visa is not approved by the time they need to come back, they can use that F-1 to come into the country. And then when the P-1's approved, when they get back to the country, we're going to send a notification to USCIS to let them know that their I-940, I-94 is updated and that they want to adjust from that F-1 to the P-1. If the P-1 gets approved in time and also there's enough time to consular process, we'll do the same thing to where, we'll do something different. We'll have them go to the embassy and get their passport stamped with the P-1 visa instead of the F-1. But probably in the circumstance that if they're leaving in a few weeks and coming back a few weeks after that, the P-1 visa will still be adjudicating on regular processing before they come back. So the most likely situation in this circumstance is that they'll extend the F-1 visa, come back on that, and then the P-1 visa will be approved sometime after that. And always remember that you have the opportunity of adding premium processing to any P-1 or O-1 visa application as long as it's still under processing to get those 15 business days response time. So I hope that I hope that athletes out there and their parents find this helpful to know the nuances between the consular processing portion of switching between F-1, P-1, and O-1 visas. Thank you very much.